Hello guys, welcome back to the channel Ajay Sharma Law. So today we are talking a very important landmark case law that changed how the police works in India. It's called the Lalita Kumari versus Government of Uttar Pradesh. Have you ever heard a story where a person goes to a police station to report a serious crime, but the police officer refuses to file a report? Well, that's exactly what this case is about. It's a huge case that went all the way to the highest court in India, the Supreme Court, to answer the one simple but the critical question: are the police legally obligated to register a complaint when a serious crime is reported to them? So let's start with the story. The case begins with a minor girl named Lalita Kumari. One day she was kidnapped. Her father, a man named Bhola, rushed to the police station to file a complaint. He gave a detailed written report about the kidnapping. Now, kidnapping is a very serious crime, what the law call a cognizable offence, which means the police can arrest someone without a warrant and must investigate immediately. But there's the problem. The police officer in charge refused to register the report. If it was until the father went to a senior police official that an official report or FIR, a first information report, was finally filed. But by then the precious time had been lost and the family felt no real action was being taken. Frustrated, Lalita's father took the matter to the Supreme Court. The fact of this case are: the case originated from a writ petition filed by Lalita Kumari, a minor girl, through her father. Her father had filed a written complaint with the police about his daughter kidnapping, but the police officer in charge did not take any action, and FIR was only registered after the superintendent of police was approached. The petitioner grievance was that even after the FIR was registered, no steps were taken to the apprehend the accused or recover the girl. This particular case, along with the several other conflicting judicial decisions on the same issues, led the Honorable Supreme Court to refer the matter to a large bench to clarify the legal position on the registration of FIRs. These are the facts of Lalita Kumari versus Govt of U.P. This single case brought a long-standing issue to a head. For years, there had been conflicting the opinions from the different courts. After the police discretion, could a police officer decide not to register a complaint? Did they have the right to conduct a preliminary inquiry first to see if the complaint was real or credible? The Honorable Supreme Court decided it was the time to settle this one and for all. So basically that's the question: whether a police officer is bound to be registered an FIR under the section 154 of CrPC 1973 earlier upon the receiving information relating to the commission of a cognizable offence, or whether the police officer has the power to conduct a preliminary inquiry before registering the FIR. The Honorable Supreme Court decision and guidelines. The Honorable Supreme Court, after the hearing the arguments from all the sides, delivered a decisive judgment. The court held that the registration of an FIR is mandatory under the section 154 of the CrPC if the information received discloses all the commission of a cognizable offence. I hope you all know about that. The cognizable offence are defined under the CrPC and earlier in the CrPC, but now in the BNSS 2023. Basically, cognizable offence are those offences in which the police officer can arrest a person without warrant. The court issues a set of guidelines to police forces across India to ensure the compliance with this ruling. Key aspects of the judgment include the mandatory registration. The court held that if the information given to the police clearly discloses a cognizable offence, the police officer has no option but to register an FIR. The use of the word shall in section 154 clause 1 of the CrPC indicates the mandatory nature of this duty. In 2013, a 5-judge Constitution bench of Honorable Supreme Court delivered its landmark judgment. The ruling was clear and powerful. The court said that under section 154 of CrPC, the police must register an FIR as soon as they receive the information about a cognizable offence. The word shall in the law leaves no room for the discretion. It's a legal duty, not an option. That's decided by the Supreme Court. The court also clarified a few key points. Let's discuss one by one. No preliminary inquiry for veracity. A preliminary inquiry is not permissible to verify the truthfulness or credibility of the information. The police jobs at this stage is only to ascertain whether the information as provided discloses a cognizable offence. Clarify that no credibility test. The police cannot refuse to register a report just because of they doubt the information or verify the truthfulness of the complaint is what the investigation is for and not something to do before the FIR is filed. Permissible preliminary inquiry. The judgment did, however, carve out a limited exception in certain specific categories of cases. A preliminary inquiry may be conducted to determine if a cognizable offence has been committed. This inquiry is for the limited purpose of ascertaining the nature of the information, not to its veracity. Its mean, courts also clarify that the limited exceptions. The court did, however, recognize that in a few specific type of cases, a brief time-bound preliminary inquiry might be necessary. This is only to find that if the cognizable offence has actually occurred. Number first, matrimonial disputes, family disputes, commercial offences, medical negligence cases, and corruption cases. Time limit for preliminary inquiry. The court mandated that a preliminary inquiry, where permissible, must be time bound and should not exceed 7 days. The court also said that if a preliminary inquiry is needed, it should not take more than 7 days. Consequences for non-compliance. The court emphasized that action must be taken against the police officer who failed to register an FIR despite being given the information about a cognizable offence. Journal diary. All information received relating to the cognizable offences, whether resulting in the registration of an FIR or a preliminary inquiry, must be meticulously recorded in the police station's journal diary. So what did this case change? The Lalita Kumari judgment is now considered one of the most important decisions in Indian criminal law. It took away the power of a police officer to arbitrarily refuse to file complaint, which often left victims without any legal recourse. Basically, it solidified a fundamental right for citizens, the right to have a serious crime reported and investigated. It made the police more accountable and ensured that the wheels of justice can be start turning for anyone who report a crime. Thanks for watching, guys. If you have any questions or another case you would like us to explain, let us know in the comments below. Don't forget to like, share and subscribe. Well, see you in the next video. Okay, bye bye guys.